Law Simplified with Justice informs and educates on the law. This exciting and thought-provoking program is anchored by Justice Maduforo, a solicitor. Justice is persuasive, innovative and confident with the tenacity to take on complex topics and cases. With solid experience and expertise in making representations and advocacy in courts and tribunals, Justice provides a one-stop shop in immigration law, criminal law, employment law and contract law. For tailor-made legal advice, Law Simplified with Justice, bringing the best to the audience.
Hello, and welcome to Law Simplified with Justice. Today is a very special day because I'm discussing a very special topic, a very fundamental and basic topic today. It is fundamental, it is basic, it's important that we tune in to understand and to assimilate this topic. I am your host, Justice Maduforo. I welcome you to this exciting program that comes your way on this same beautiful channel, Believe TV, Sky Channel 593. I remain Justice Maduforo, a solicitor. You know how I do it in this program. This program does not give you legal advice. Rather, this program awakens your consciousness. This program enables you to take action when you are sleeping over your rights. That is what this program is all about. This is not a program that advises you. And that is why, as you can see on the screen, that this program enables you to contact me so that you can come in, sit down, and give me instructions so that I can advise you tailor-made, ladies and gentlemen. And then you can run with whatever I've advised you, but not on this program. So therefore, a disclaimer, do not act on what I say or my guests say on this program. They are merely our opinion and my opinion, not legal advice. Ladies and gentlemen, I tell you the truth that law is a social change. It's a social tool, and it's a tool that changes the social psyche and actions of people. And it's important that everybody complies with it. Today, I'll be discussing, and as I've been discussing the series, if you've heard and watched, those of you who are fans of this program, you will notice that I have been dwelling on a very important topic and series as well. And I've been discussing over the period of a few months now, protected characteristics under the Equality Act 2010. And these protected characteristics run from your right not to be discriminated against, your disability, your age, your racial or religious belief, your marriage, your civil partnership, or your gender reassignment or sexual orientation. I have discussed these things with you. And I want you to go to the YouTube and type in my name, Justice Maduforo, and read and also listen if you want to catch up with most of those programs. They are on the YouTube for you to catch up, ladies and gentlemen. And also, you can add me on Facebook to discuss this. Ladies and gentlemen, you know that I have dedicated to discuss employment law for a while. The reason being that it's very key, especially in this economic climate where a lot of people are being either sacked from work, not because of the economic decline in their company, but as a result of one discrimination or the other, which is why, as a result of my practice for a period of time, I've been appearing in Employment Tribunal and Employment Appeal Tribunal. I decided to roll out these protected characteristics and deal with it so that you understand and stand up and take back your dignity. Ladies and gentlemen, today, still in employment law, I am talking today, and the topic of discussion today is raising grievance at your workplace. Raising grievance at work. Ladies and gentlemen, this is employment matter as well, because grievance can only be raised while you are in employment. And I will discuss that as well as I go along. So, before I dive into that and do justice to this topic I've just raised, it's good for you to understand that I am also a specialist in dealing with crime. So, I have dealt with from simple matters to very serious, complex criminal matters. I am police station and court duty solicitor of England and Wales, and I can represent you at the police station free of charge. You know that? And also take you on to the magistrate court, to the crime court. And if your case needs to be reviewed, I take it to the commission of review, and also to the court of appeal and appeal any decision either by sentence or conviction. Ladies and gentlemen, you have me. At any time at the police station, you get it free of charge. Pure advice given to you, to your words, to your friends, to your sister or brother. So you have me. Take the number on the screen. 079-3172-7597. That's what you need in case you are being called upon, either voluntarily or you will be mistakenly arrested to the police station. Do not just go and just talk to the police officers on the belief that you have done nothing wrong. Seek me. Ask for me. The number is just there. Pass the number and the name to the custody officer in whole of England and Wales, and they will contact me immediately, and I will come to assist you and advise you accordingly. And that is criminal law, talking there. Now, in immigration law. You know that. Most of you would have benefited, have come to me, and have gone home smiling. I will run with your immigration matters. You know that. And most of you have seen me appear in employment tribunal and in immigration tribunal as well. And you could see the force and the veracity and the vocality and the expertise of which I assume, and also the empathy which I put in your case. And some of you have gone home smiling. Any matter in employment, immigration law, changes are in immigration law. Definitely, as I talk to you today, there are changes and policies and guidance going on. Recently, the changes to discretionary leave has changed. The forms have changed. Fees have been introduced into the immigration appeal tribunals. They have all been introduced, and changes are all there. You don't want to go and do oral hearing or written hearing if you are not yet prepared for your case and spend such money, ladies and gentlemen. So anything about immigration, contact me, from your entry clearance application to your asylum application, to an application to naturalize, to application for citizenship, to application or whatsoever that you are applying in immigration law. That you have me. To bail applications, have you been unheavily held in the detention camp? You need a bail application to put in a vigorous advocacy to get you out of detention. You got me on the phone there. 079-3172-7597. That's the number you need. And then go talking about contract. You know I am specialist in contract drafting, contract review, contract monitoring, and contract completely in performance and in monitoring of any contract that you're dealing with, from domestic to commercial, be it in oil and gas, be it in engineering, and be it in construction, in terms of the contract you go into, be it consortium agreement, be it specialist agreement, be it a specialty agreement, be it all sort of agreement you're going into. You have me, ladies and gentlemen, in contract. You have me there. Take the number of the screen, 079-3172-7597. That is what you need. Your time has come. Let me also say thanks and also a special gratitude to my pastor and the general overseer of VPA, Pastor Alex Omokodu. I so much love you. Your time has come. Ladies and gentlemen, let me move on now to the topic of discussion today. What are we discussing today? Raising grievance at the place of work. Raising grievance at the place of work. What is raising grievance? You have been employed. You are under the employment of an employer. And along the line, you have felt that you have been discriminated, or you have been dismissed unfairly, and you have been treated less favorably, or do you feel that also that your pay has been deducted, also you've not been paid and received equal pay amongst your peers? These are the things that you raise grievance about, and you have been discriminated upon. And you also, regarding your leave, regarding your part-time work, regarding schedules, regarding all sort of things that you know that these are commonplace claims within the employment tribunal. And you know that the employer has treated you, or the way you have received this at receiving end has not been completely fair. And the question now is that, what do you do next? Now, ACAS code, A-C-A-S, ACAS code is very essential. ACAS code guides you on how to raise a grievance, to start from there. You see, you can always understand what the code says. But the topic of my discussion today is not about leading you to the step-by-step of how you raise this grievance. I am going to be dealing with what you are about to raise, or what you intend to raise as a grievance in your place of work. And that is why you constrain yourself to this discussion today, because it's not about the procedure. I will talk about the procedure, but the issue now is that the content of the grievance which you wish to raise. That is very key and very important, ladies and gentlemen. And that is why I've seen a lot of people destroy their case from raising unactionable claim, or raising grievance that completely is out of question, grievances that actually shoot themselves back, and grievances that does not hold water, grievances that cannot be actionable, grievances that does not come under any claim whatsoever, and they raise these grievances and discuss before their employers. Remember that when you raise grievances, it goes to your file, and therefore it is important that your grievance makes sense and your grievance is on point. What do I mean by that? I've seen a lot of people come to my office and discuss their cases, and especially where they intend or they have already lodged the grievance. And then along the line, issues come up. They come to me. And when I would discuss this, I found out that there shouldn't be any grievance whatsoever, or that a grievance ought to have been streamlined and issues mapped out and clearly stated, and before you can go into grievance. So grievance, simply in a case code, is where you raise a complaint regarding the way you have been treated by your employer. The rule of ACAS code provides that you first of all raise this with your manager informally, discussing this with your manager. If that has not been dealt with according to your pleasure and where you feel it's been dealt with, then you can take it further by putting that in writing, and then that will be a meeting will be constituted in which you will come in and discuss the written complaint that you've put down against either your fellow employee or against your line manager or your employer in terms of the hierarchy in your place of work. Raising grievance at the place of work is very key. It could either sustain your claim or diminish your claim or completely exhaust and extinguish your claim. So it's important that your grievance which you're raising is actually on point. And that is why you have me, Justice Maduforo, 07931727597. This number is what you need. You come to my office, and let me tell you this, because I also, as along the line, as I discuss this, but it's important to mention this, that when you come to see me, you have to pay a consultation fee. And therefore, it's actually needless to call me if you know you want to discuss your case with me, because you have to pay a consultation fee before I can discuss your case and advise you. I'm giving you an expert knowledge advice of which you will run with. It will either favor you and also spare you a lot of inconvenience. And it's important that you stick to this, ladies and gentlemen. So consultation fee is payable. You have to pay consultation fee when you come to see me. So if you pick this number on the phone, on the TV, and you want to call me and you want to discuss a case, please, I do not want to discuss a case on the phone. Either a concession fee has been paid before we begin to go into the details of your claim or details of your matter. It's important you understand that, ladies and gentlemen. Moving on to that. So the ACAS code has two arms, basically. And a code is for disciplinary, and the other one is for grievance. And if you go to YouTube, you can see that I have discussed grievance on this program. We have discussed raising grievance and dealing with disciplinary, dealing with disciplinary procedures in the place of work. I dealt with that. You can catch that on YouTube and listen to that as well, and issues are raised there. It is not complete legal advice, as I said. You have to also, your case is peculiar from the other, because what I give is a generic view, which does not apply to you. So therefore, you must come down for me to take detailed instruction and discuss your case accordingly. So ladies and gentlemen, cracking on that, the code is two, disciplinary and grievance. So I'm discussing grievance today in terms of not following this code. This code is a guide. It is not a law. Ladies and gentlemen, this code is a guide. It is not a law. Your employer may choose to jettison it. Employer may choose to throw it away. Employer may choose not to listen to you when you raise it. But you know what? You are doing yourself a massive favor, because if they don't follow that process or instigate and institute that process, and your claim goes to court, and your claim has a prospect of success, and your claim succeeds, and therefore what happened afterwards? For failing to comply with that code will stick your employer, obviously, a very serious consequence, being that you expected, and the court and tribunal, depending on the level of non-compliance with this code, the tribunal has the power to award you more than at least 10 to 50% upwards in your award of your claim. So therefore, if it's not complied, either you as a claimant or the respondent, none of them complied with it, and the claim is proceeded straight to the tribunal, and the tribunal found in your favor as a claimant, but however, you did not follow this step, and therefore, the court, the tribunal, has the power to decrease your award from 10% to 50% to some extent. And I will discuss, and I think I've mentioned this in this program, to some extent, if you are negligently contributing to the claim. Therefore, you may expect to see your 100% award wiped off. It is important, because this systematic employment law is not just saying you did this to me and therefore I want to go to employment tribunal. No, there are sequence to follow. There are terminologies to abide with. There are rules and procedures to follow. These things you're not seeing. For instance, you are not getting them, and therefore it is going to be difficult for you to sustain your case in the employment tribunal. Ladies and gentlemen, raising grievance at the place of work is a topic today. And what I mean by that, as I said to you earlier on, is that your grievance must be made known. The first step first is to inform informally your manager. And if that informal discussion does not produce result, or that produces result which you do not like, and I guess so, because some of this will always tilt in the favor of the employer to say that what you're raising is baseless or unmeritorious, they may raise that to you. The question is that will you accept it? then you move to the next step, and then you put it in writing, pen it down in writing. The procedure is that once that has been put in writing, your employer must raise a meeting within a reasonable time. That is the question now. What is a reasonable time? A reasonable time is important for your employer to constitute a meeting whereby your written grievance will be discussed. Ladies and gentlemen, your written grievance will be discussed. You'll be given an opportunity to discuss your case. Now, let me stop there to say that it's important that before you start pinning down your grievance, that you rush to see me. Because as I said earlier on, your grievance may be littered with completely unactionable claims, completely malicious claims, completely unsubstantiatable claims, be completely littered with things that does not in any way exist. You cannot establish, you cannot point to the evidence. So it's important that before you sport out your good name in the place of work, come and see me first. It does not cost you nothing. A party consultation fee will save you quite a load of inconvenience in the future. Do not rush there and begin to speak to your line manager or your manager or raise grievance by email or by phone or by text without coming to see me first, without speaking to me first, without getting advice first as to whether or not your application or your grievance actually makes sense or it does not make sense. Because it is very important. I can see that most applications that have been struck out from court in the tribunal is a result of baseless claims, claims that lack prospect of court success, claims that are completely malicious, claims that does not in any way bring any claim whatsoever or point to your claim. The claim form is pretty easy because you only tick the box as to what you're claiming. But the body and the content of your claim will have to correspond with the box you ticked in respect to what you're claiming. So what you tick the box and say unfair dismissal, and the content of your claim or the particulars of claim which you have penned down in the form does not comply with anything or raise anything that constitutes or relates to unfair dismissal whatsoever. And therefore your case stands to be dismissed and the time you spent so far is wasted. It costs you nothing but a consultation fee to establish your case as to whether it is strong to crack on or not. Ladies and gentlemen, I will take a very short break. When I come back quickly, I will discuss now the advantages and disadvantages of not raising or raising this claim, and also the content as I started discussing earlier on. So stick there, don't check that dial. I remain Justice.
Law Simplified with Justice informs and educates on the law.
Welcome back to this favorite program, Law Simplified with Justice. I remain Justice Maduforo, your host. I am a solicitor. Ladies and gentlemen, as I was speaking before, I went over to have a very short break to discuss this matter. I was discussing the grievance procedures. It is important because what I've seen so far, it does not give me encouragement at all in respect to people who have raised grievances without completely establishing exactly what claim they are raising. Now, as I did say, the informal writing, the meeting takes place. First of all, before the meeting, your employer will have under the code, a CAS code, deal and raise this meeting within a reasonable time. What is a reasonable time? As I did mention to you earlier on, is that this reasonable time have to be constituted reasonably within 28 days. That should be a meeting set up to discuss the written grievance which you've raised. Now, once this meeting has taken place, a decision is made. What decision is made and in your favor and deals with the complaint you raised, and you are satisfied with the decision or the outcome, then that ends the matter. However, if, which unlikely, I can tell you very seriously here and authoritatively that most grievance procedures or grievances raised by the employer against the employee against the employer, most of the outcomes have been 96% against the employee. Because no employer accepts liability. No employer should accept liability. No employer is obliged to accept liability whatsoever of what you've raised. But accepting that will be accepting the claim, which may in the future, this thing continues against the employee. Employee comes back now rather than going again to the tribunal, to going through the grievance, goes straight to the tribunal, and then will produce a copy of the initial matter which the employer have accepted and apologized and probably tried, attempt to amend, but couldn't amend, but which now leads to this employment tribunal claim. So it's important because at the end of the day, in employment tribunal will have to see that record of the outcome of the previous grievance procedure meeting, which was held an outcome. So ladies and gentlemen, no employer accepts liability, and you should not and must not accept liability, but must deal with the matter. Rather, they may coin it or change the wordings or the tone of that complaint in such a way that if there is any lapse on the part of the employer, will accept one way or the other, but not completely or in a whole, wholly or partly accept your allegation. Therefore, it's important you understand that. And in that process, what happens afterwards? Now, once the outcome has come and you're happy with it, that's fine. The matter ends there. And as I said to you, 96% of such grievances raised are never accepted or are admitted by the employer. Therefore, it moves to the next stage. It's been refused, and your allegations which you raised have been denied. Then what happened? Which means that whatever you think you've been passing through will continue unabated. Now, what is the next step? The next step is that the rule expects you to appeal that decision. Now, when you appeal that decision, they are also under the duty to respond to you. Pause there, ladies and gentlemen. If you raise appeal and the appeal is still ongoing within your employer and a decision has not been made, and you must fix your mind on the fact that a 3-month period on open window is necessary, of which that if this 3 months expires and your employer, sometimes they can bring in such delay tactics. If your employer brings in a delay tactics to listen and to deal with your appeal, and 3 months expires, of which you are entitled to bring a claim in employment tribunal, and it elapses, ladies and gentlemen, you may be lodging your claim out of time. Therefore, you must be smart. That's why when you come to me, I guide you, I follow you up, and I advise you. You know, will not go wrong. You will never go wrong when you come to me, ladies and gentlemen, in respect to any matter relating to employment, any matter relating to immigration, any matter relating to crime, criminal law, and any matter relating to contract law. You will never go wrong once you stick with me, as long as the obligation on your part is fulfilled, and which is paying your fees for me to address and to represent you. And obviously, I'm very considerate, ladies and gentlemen. I want to point that out, very considerate. Those of you that have come to me have seen that not only do I give you the quality, the best you can ever get anywhere, but also considerate of the price. Ladies and gentlemen, so that is it. That is it. If the employer decides now to say, no, your allegation is false, baseless, unfounded, malicious, and whatever it is, and refuse, then you go to the employment tribunal. I will refer to for your appeal. And once the appeal is pending, remember 3 months period is important, and depending on exactly what you've raised, basically. So the point of this program, of which I am raising your consciousness on, is the fact that the contents and particulars of your grievance must be provable. And that is why you come to me, to rake out, take instruction from you, and make sure that there is actionable claim or actionable grievance that you are raising. You may feel you have great cases against your employer, but when you come to me, you can see that those cases you think are high will be dissolved, either because they are worthless under the threshold and procedures that you need to fulfill, or that they're absolutely nothing at all whatsoever, or that you have enormous evidence to assist you. So it go either way. But in that case, you know exactly what your case is all about, and you can run with it vigorously. Ladies and gentlemen, I say this is important. And then appeal has been heard. And also, I can assure you again, 87% of appeals in grievances raised never go in the favor of the employee, always employer, because no one said accept liabilities. And it is not expected of you to accept liabilities, especially because the law has so many windows of which you can attack a case. And when you attack cases from the law point of view through these windows, it either reduces the worth of evidence against the employer or in favor of the employee. So put that in your mind when you're dealing with that. And now, dealing with a very important issue about appeal, and also dealing with an important issue regarding the time frame. And also dealing with an important issue if in the course of your grievance which you raised might be as a result of unfair dismissal or a sacking or dismissal. Because 80% of claims that have been raised or grievances that have been raised is a result of unfair dismissal or a pending constructive dismissal which is pending, of which that from what you've been experiencing in the place of work, especially unequal pay and other things that you go through, leads to constructive dismissal. And in that respect, you want to raise grievance. Ladies and gentlemen, the question now will be, that's what is called in law, effective date of termination. Effective date of termination, EDT, is important because the effective termination will know where you were terminated under the calculation of the legal calendar to ascertain when you were terminated. is assuming you were dismissed and you lodge grievance, and that grievance, or you appealed against it, or you raised grievance before you were terminated, and you were terminated, and you appealed, and the appeal is to decide one way or the other to deal with your grievance. And assuming you were dismissed and you were asked to come back again, pending further investigation. Now the question is that when you refuse to abide by that agreement or refuse to abide by that offer, I use that word offer, not agreement, because either you agree or not, but refuse that offer from the employer, the question now will be, what will determine the date of termination? A lot of you have got it wrong, because in that respect, you think you're terminated when you were dismissed, not when you appealed and the appeal was upheld. The question is, what is a date, a legal date, an employment legal date, basically, in terms of when you were terminated? So that's why you come to the specialist like me to decide and calculate the calendar and accurately and deal with it. Because if you calculate wrongly, that means you may either have lodged your case out of time, or you still have not lodged the case within time, or that you still need to wait for the appeal to be exhausted before you lodge your claim. These are legal terminologies, which you may not understand or get on the internet, but it all lies to the specialist who deals with this matter in court, physically and otherwise. Now, it's important you understand effective determination. That deals when you raise grievance, when you've been dismissed and unfairly dismissed, if you're raising a claim or grievance on unfair dismissal. Ladies and gentlemen, so abiding and the content of your grievance is necessary. Therefore, do not wish it away. Do not just assume. Do not, as a result of the few money you will spend from getting legal and quality consultation and advice, and proceed to lodge grievance, which will pay you no good. And is that at the end of the day, you return back to square one to start to clean up the mess which you've already made. And it will be difficult and too late at that point in time. Ladies and gentlemen, I've been discussing this program for a while now, and it's important for me to end this broadcast today to let you know that you did not sit on your right. Do not take lives into your hands. You must ensure that you follow the procedure and lay down in your place of work in respect to employment law, which we are discussing today. If you have any issues, you know how to contact me, 079-317-27597. That is what you need. I end this program today. I tell you to take step, speak out, and do not stay there when you have been drummed and beaten down in your place of work. Thank you so much for listening to this broadcast. Tune in again on this same channel, 593 at 7:30 p.m. on other days. The time has come.
Law Simplified with Justice informs and educates on the law. This exciting and thought-provoking program is anchored by Justice Maduforo, a solicitor. Justice is persuasive, innovative, and confident with the tenacity to take on complex topics and cases. With solid experience and expertise in making representations and advocacy in courts and tribunals. Justice provides a one-stop shop in immigration law, criminal law, employment law,